With less than 2 weeks before the Supreme Court breaks for the summer, there's a lot to wrap up. Same-sex marriage, health care subsidies, and among the major cases is one that could devastate civil rights law. It concerns the question of how to define and demonstrate discrimination. Discriminatory policies and practices can seem to be neutral, but still wreak devastating effects on one group. For example, when a practice causes substantially different effects for one group, even if there's no particular evidence of intent to create that inequality, we think of it as disparate impact. And disparate impact is currently a standard legal argument in housing and education, employment, and other forms of discrimination law. Take a Texas housing agency that just happened to perpetuate racial segregation in Dallas by keeping low-income housing incentives for landlords out of wealthy white neighborhoods. Texas argued that it should not be judged by a disparate impact standard in its policy, but simply by the purity of its intention. In fact, they have argued that because the Fair Housing Act of 1968 makes no direct mention of disparate impact, it cannot be legally factored into housing discrimination cases. Now it's time for the courts to decide. And if the court decides in favor of the Texas agency, the effects could be sweeping. As many of the more controversial decisions by the Supreme Court, this one is expected to be split 5-4. Guess who might be the crucial swing vote? Justice Scalia. Yeah, the court's staunchest conservative surprised many during the hearing in January when he seemed to maybe make an argument that because Congress passed disparate impact exemptions to the Fair Housing Act in 1988, they acknowledge its existence. Justice Scalia went on to tell Texas Solicitor General that you have to look at the whole law, and when all the parts are read together, there is a such thing as disparate impact. But I wouldn't be counting them in just yet. He went on to say the fact that the NFL is largely black players is not discrimination. Discrimination requires intentionally excluding people of a certain race. Okay, so the NFL analogy is a little bit questionable at best, but it shows that Justice Scalia may not be content with disparate impact as proof. But if the data of inequality and the numbers and the maps show how pervasive segregation still is in this country, it's not enough to prove discrimination. What is? Joining me now, Janai Nelson, who's Associate Director Counsel of the NAACP Legal Defense Fund. Adam Benforado, who is Associate Professor of Law at Drexel University and author of the upcoming book, Unfair: The New Science of Criminal Injustice. Nikole Hannah-Jones, staff writer at the New York Times Magazine. And Juan Cartagena, President and General Counsel of the Latino Justice PRL-DEF. All right, what is about to happen here? Do we know?
Well, we hope that the Supreme Court is going to uphold a standard that has led this country into integrated communities, more inclusive communities since 1968, a standard that, as you said, pervades many areas of civil rights law, and that allows us to move past this focus on intentional discrimination and recognize that there's structural racism, that there's structural discrimination that is equally pernicious, equally harmful, and that tends to concentrate minorities into pockets of poverty and does not allow them to fulfill their dreams and their successes as well they should.
So let me ask this. As you talk about the ways in which disparate impact is meant to have been used to generate integrated communities, Nikole, I feel like not only in being married to a housing lawyer for all these years, but in the work and the reading that I do, it doesn't really seem like it's worked. I mean, it's a separate question about whether or not disparate impact will stand in this case, but I do wonder if the goals of the '68 Fair Housing Act have in fact led to integrated communities.
I mean, largely they haven't. Part of it is you can have a strong fair housing law, but you have to have strong enforcement. And we know that for the entire time, really except for the first 5 years of the Fair Housing Act being passed, there's been very little enforcement. With that said, disparate impact is really one of the only systemic tools that we have left. Otherwise, we're largely going to have to rely on someone knowing they've been discriminated against, which is often impossible, and then actually going to an agency and seeking redress.
And then, am I right then, the other piece of it is that we'd have to be able to peer inside the mind of the discriminator and say that there was intent there.
Right.
Yeah, and I think that's what really worries me. I tend to think that 5 justices on the Supreme Court believe that racial bias it equates with a racial animus. And I think the available psychology suggests that that's only half of the story, right? When we see these tragedies, as we just saw in South Carolina, that's part of what we're thinking about when we're talking about racism in this country. But there's a whole nother story out there that involves well-intentioned people who believe they are egalitarian, making decisions and acting in a way that creates terrible harm to members of the African American community, and that's in housing, that's in healthcare, and that's in criminal law. And so I worry that the Supreme Court thinks, well, you know, we cross out racism from our laws, and then we're all set, and that's simply not true.
You know, it's that point that there's a way that these murders in Charleston, rather than revealing more clearly the continued nature of racism in America, might actually help to obscure it, because if your racism doesn't show up in the church with a gun, then it's not racist. If it just shows up in a map of Dallas, Texas, where people live in totally different neighborhoods, then we don't think of it anymore as racial bias.
And that's so true. And you know, from the perspective of the communities that are being marginalized, excluded, who cares?
Right.
Who cares?
Who cares if you meant to do it or not?
Exactly.
Right.
You're still excluded. You still don't have adequate housing opportunities. And the way this dovetails with school segregation is so key. I mean, housing segregation is the main cause of school segregation because of neighborhood schooling patterns and where attendance zones. We're talking about the ramifications across many sectors here should the Supreme Court knock this down.
And so housing segregation leading to school segregation, but also environmental impacts, health impacts, employment, transportation, all of those pieces.
I mean, there's a reason why this was the last civil rights law to be passed, because this is a civil rights law that's at the root of really every other racial injustice. If you want to find a racial injustice, it can be led to where you live. And I think it's also important to acknowledge, like, there's this, it's like the Donald Sterling effect. Donald Sterling was running housing where he was discriminating against Black and Latino renters for years, and the media knew this.
But it's not like with the smoking gun tape, right?
We cared when he called some other prominent Black folks' names, but we didn't care for all of the years where his policy was actually keeping Black folks out of housing.
So connect that then for me, Janai, to legal strategy. If the worst thing happens, in that disparate impact goes down, is it just housing? And I don't mean just, given that, you know, we've just talked about how housing is connected to all these other things, but what other aspects of civil rights law are vulnerable here?
Okay, so should the Supreme Court decide to depart from what 11 circuits that have opined on this issue have decided is a lawful standard, should the Supreme Court decide to do this very aberrant thing, then we will be faced with the challenge of seeking legislation to try to rehabilitate the Fair Housing Act. We also can rely on a lot of state laws. A lot of states are far more progressive in their housing, their fair housing laws, than we see at the federal level.
Oh, the progressive states has not been my life experience
but
as a Southerner.
There are about 40 states, in fact, that have fair housing laws, and it's up to us to ensure that they are being enforced. It's up to us to seek new federal legislation, and it's up to us to protect the other civil rights standards that rely on this crucial disparate impact concept and make sure that they don't get eroded as well.
Adam, we only have about 30 seconds, but can you explain to me how science might help this? I mean, we actually know some things that, if the court understood them, might help them on this.
I think it's about bringing the case, explaining why we need disparate impact theory at all. I think that a wide sector of the American public thinks that having Barack Obama elected as president means the end of racism in our country. And yet, if you look across all areas of law, we know Black men get higher bails. We know they're more likely to be abused by police officers. They're more likely to get the death penalty. We know in terms of housing, there are disparate impacts. We know in healthcare, there are disparate impacts. And so we need some evidence of why that happens. I think the science offers that, and that's implicit racial bias. Good people with good intentions can act in ways based on stereotypes which are pervasive in our culture.
I want to say thank you to Nikole Hannah-Jones and to Juan Cartagena and to Janai Nelson and to Adam Benforado, whose book upcoming is Unfair, the New Science of Criminal Injustice. I know we got just feels like no time yet with this panel. That said, that is our show for today. I want to say thank you to those at home for watching. I'm going to see you next Saturday, 10 a.m. Eastern. Right now it's time for a preview of Weekends with Alex Switt.